It is very clear now that Trump and Putin are in this strange love affair, and it's at the expense of the Ukrainian people. So it's recently been announced that Trump is most likely going to cancel TPS for Ukrainians. For those of you who don't know, TPS is referred to as temporary protected status, and it's usually designated for a country that's experienced some sort of devastation or tragedy or natural disaster. For example, Haiti received TPS designation after a very devastating earthquake. Some countries get it during wars, which is what happened for Ukraine. And then after Ukraine was designated for TPS, there was the Uniting for Ukraine program, which allowed Ukrainians to enter the United States with parole and then get TPS after they enter the US. So if you're Ukrainian, let me start by saying I'm very sorry that you're going through this, and I apologize on behalf of the United States for what our president is putting you through. I know that if you're Ukrainian, you have a lot of questions right now about what your future might look like. So I want to do the best that I can to answer some of the questions I've been receiving in this video. So first of all, if the Trump administration follows through with this and cancels TPS, it's not going to mean that everyone who currently has TPS is going to all of a sudden be out of status. It usually means that the designation period for TPS will remain in effect and that the redesignation will be canceled. So the Trump administration will just decline to redesignate Ukraine for TPS. Although they can and have changed prior TPS designation periods, they can shorten or reduce how long a designation period is for by rescinding it, changing it or editing it in the Federal Register. It can happen, and it has happened. So it's not beyond the realm of possibilities, but probably people who have TPS will continue to have it until their current term of TPS expires. But then what happens? So TPS, by its very nature, as conservatives will point out, is meant to be temporary in nature. It's never meant to be a permanent long-term solution. So anyone who has TPS really needs to start thinking about what the next steps could be. So let's go through some of that right now. Some people with TPS might be able to benefit from employment-based immigration options. I, admittedly, am not very experienced with employment-based immigration. I focus my practice on family-based immigration, asylum, naturalization, and deportation defense. So I do pretty much everything except employment-based immigration, which is a whole different animal by itself. So what we're going to be talking about today are two other options, and that's family-based immigration, and the other one is asylum, which is a possibility if you don't have a better option available to you. Family-based immigration is actually more complicated than a lot of people realize because there are two different classifications for family-based petitions. One of them is immediate relative petitions, and the other one is preference category petitions. For immediate relative petitions, you get a lot of benefits. You can be completely out of status and become a permanent resident through immediate relative petitions, and there are no visa waiting times. There are no priority dates to worry about. A visa is automatically available in those categories. So what are immediate relative petitions? There are three, but really only one of them is gonna help the majority of Ukrainians who are here. The one that's gonna help most people is marriage to a US citizen, and they must be a US citizen. If they are a permanent resident, that's not an immediate relative category, that's a preference category, which has a lot more requirements. So another immediate relative petition is when a US citizen who's over the age of 21 files a petition for a parent. That is also an immediate relative petition. So for example, if you have a parent who entered the US legally and you are a US citizen who's over the age of 21, you can probably petition for them and they could probably apply for a green card filed simultaneously with that petition in a one-step adjustment of status. I say probably because I don't know the exact facts of your case, but usually this happens to be true. And if you're wondering whether or not you qualify, This is what I focus on, so you could always schedule a consultation directly with me to go through the available options that you might have. The third possible immediate relative petition is when a US citizen parent files a petition for a child who's living with them unmarried under the age of 21. And there are a couple other requirements, but those are the main ones. So these are the three categories where it doesn't matter if you're currently in TPS or completely out of status, doesn't matter if you have an asylum application pending or not, you can still benefit from these three categories of petition. Preference categories, on the other hand, are much more complicated. If you Google US Visa Bulletin, the first link will bring you to the Department of State's Visa Bulletin, and you'll find a couple complicated charts on this website. What you'll notice is that the charts have different categories. For example, spouses and children of permanent residents, siblings of US citizens, people who are over the age of 21, petitions for adults who are over the age of 21, petitions for adults who are over the age of 21 and married. These are different preference categories, and they all have different processing times. For example, at the time that we're filming this video, the visa backlog for the spouse of a permanent resident is around 9 months. What that means is first you would need to file the I-130 petition, and then once the visa becomes available, then your spouse can file the green card application. And there are caveats. At the moment they file that green card application, they need to be in a valid non-immigrant visa status. If they're out of status, your green card application is going to get denied. In that situation, you might need to wait for the permanent resident spouse to naturalize, become a US citizen, and then petition for the immigrant spouse so that they could fix their status while they are out of status. So there are major complications when it comes to preference categories. Sometimes there are no options for you to adjust status within the US. In fact, most of the time, preference category petitions eventually need the consular process by leaving the US. And that creates additional complications. First of all, the Trump administration right now is gutting the consular process. Consulates are losing funding, resources, things are gonna grind to a stop or at least to a trickle. They're gonna be very slow for the next 4 years. I feel very bad for people who need to use the consulates to try to enter the US during the next 4 years, because you're gonna have to go through some serious hardships trying to navigate that process. And to make matters even worse, if you're unlawfully present in the US for more than 180 days, or even worse, 1 full year, the moment you leave the US to go to a consulate interview so that you can get your green card and re-enter the US legally, you will be subject to a 3-year bar if you overstayed by 180 days, or a 10-year bar if you have 1 year of unlawful presence before you leave the US. So if you're gonna be subject to those bars, you need to apply for an unlawful presence waiver before you leave. But wait, there's more. To qualify for an unlawful presence waiver, you can only apply if you have a spouse or a parent, and that spouse or parent must be a permanent resident or US citizen, and you need to demonstrate that that family member will suffer unusual hardships if you're not allowed to remain in the US or return to the US after you attend your consulate interview. If you can sufficiently demonstrate that your qualifying family member will experience unusual hardships, the government will probably approve your unlawful presence waiver, and only once that happens is it safe to depart the US to attend your consular interview and re-enter the US as a permanent resident. And even then, there are still things that could deny your re-entry. The government might find other reasons to deny your entry. For example, if you've ever entered unlawfully through the Mexican or Canadian border and you entered with other people, the government might allege that you're subject to the alien smuggling bar, which means that you're basically like a human trafficker. I've seen this happen in the consulate in Mexico, Ciudad Juarez, even when people enter with their own children. A mother enters with her 2 children, marries a US citizen 20 years later, applies for the unlawful presence waiver, gets approved, goes back to Juarez for the interview in the consulate so that she could finally fix her status. And when she's there, They deny her visa and say you're subject to the alien smuggling bar because when you entered the US, you assisted your children in entering the US. This was actually a big problem back in the day in the Mexican consulate in Juarez. My understanding is that it's a little bit less of an issue now, but this could totally begin popping up again as the government is finding new and creative ways to deny immigrants from lawfully living in the United States. The other option that Ukrainians might have available to them after TPS status expires is an application for asylum. Generally speaking, you must apply for asylum within 1 year of entering the US, but there are exceptions. One notable exception is changed country conditions or changed personal conditions. And something that qualifies as a changed condition is losing your prior lawful status. So as soon as you lose your TPS, if you apply for asylum within a reasonable time, which is defined differently by all the courts, every judge will look at the circumstances and make a determination. I recommend that within 1 month of losing your status, you apply for asylum if you have a viable asylum claim. In that situation, you might qualify for an exception to the 1-year asylum filing deadline. Do not apply for asylum without an attorney. If you want to apply for asylum without an attorney, I urge you to read the statistics on the number of applications that are denied versus the number that are approved when you use an attorney versus when you don't use an attorney. Asylum is not intuitive. It doesn't make sense. You might believe that just explaining that you're gonna die if you return to your home country is enough. It's not. In fact, many people meet that burden and are regularly denied asylum and then deported from the United States. Before you apply for asylum, you really need to speak with an immigration attorney, specifically someone who focuses on US immigration law. Once you apply for asylum, you've begun a chain reaction that is going to take years to resolve. It can take up to 10 years sometimes for the government to even make a decision on your initial asylum application. And if they deny the application, they'll refer your case to immigration court to begin removal proceedings. Once you are in front of an immigration judge, you can apply for asylum again and have a judge hear your case. You'll have more procedural rights once you're in front of a judge, so you get a second bite at the apple. Or once you're in front of the judge, you could also apply for any other defenses from removal that you might have available. If you've actually been in the US for 10 years at that time and you have US family members such as a child, spouse, or parent who's a permanent resident or US citizen, you might also qualify for other things such as cancellation of removal. When it's finally time for the government to make a decision on your case, if they send your case to immigration court, there might be policies in place that allow you to just terminate removal proceedings and avoid a deportation order. We won't exactly know what's gonna happen. It's unbelievably stressful for the asylum applicant because they are establishing a life in this new country and they don't know whether 10 years from now they're gonna receive a deportation order or permanent residence. So I feel very bad for the Ukrainian people right now. This is really sad and it's really disgusting what the Trump administration is doing to this group of people who the prior administration welcomed into the United States and who the American people at large welcome the Ukrainian people into the United States. So it's not fair. And it's not right for the President of the United States to just unilaterally decide on behalf of the American people that Ukrainians are at fault in this greater war and that they are no longer protected in the United States. Alright guys, that brings us to the end of today's video. If you are interested in learning more about family-based immigration, citizenship, asylum, or any changes to the immigration policies under the Trump administration, be sure to subscribe. I'm trying to put out at least 5 videos a week for the next year on these topics. If you're interested in learning more about my services, you could always schedule a consultation directly with me. I focus on family-based immigration, naturalization, and deportation defense, including asylum applications. Thank you guys for watching, and I'll see you guys next time for another video.